Hi, I'm a staff attorney at Houston Volunteer Lawyers, and today I'm here to talk about evictions. First, what is an eviction? An eviction is a lawsuit filed by a landlord against the tenants or the people in the landlord's property to remove them and their belongings from the property. The first step in eviction is something called a notice to vacate. A notice to vacate is required to be given to tenants before an eviction is filed. It also has to be in writing. It is usually left on the inside of the door of the residence. It can also be mailed. It can also be hand delivered to the tenant. And in certain circumstances, it's allowed to be left on the outside of the door. The notice to vacate will say how long the tenant has to stay in the property before the landlord will file an eviction. Most leases in Texas allow a landlord to give a 24-hour notice to vacate. If the lease doesn't say anything, then Texas law says it has to be at least 3 days. In certain other circumstances, a landlord may give more time in the notice to vacate. After the period in the notice to vacate has ended, and if the tenant is still there, the landlord is allowed to go to the courthouse to file the eviction petition. After the eviction petition is filed, a constable will deliver the citation and a copy of the petition to the tenant. All eviction citations are required to be delivered by the constable in Texas, and they will either normally hand deliver it to the tenant or another resident of the household, or they can tape it to the outside of the door. The eviction citation has some important information, including which courthouse the eviction trial will be, what day it will be, and what time it will be. It will also have the case number and a copy of the petition. The eviction petition is where the landlord states the reasons to the court in writing that they believe that they should have the right to evict the tenant. It will state any breaches of the lease, any unpaid rent, and how much unpaid rent if there is unpaid rent. The next step in the eviction is the actual trial. If you're going to go to trial, it's important to show up on time or early so that you can hear your name called. Right now during COVID, a lot of courts are allowing people to appear by telephone or by video, but you have to make arrangements with the court in advance if you want to do that. If the tenant misses the trial, it's very likely that something called a default judgment will be taken against the tenant. That means that even though the tenant is not there, the judge is allowed to issue the eviction or grant the landlord the eviction in favor of the landlord because the tenant didn't show up. That's what a default is. If you go to court, both sides are allowed to put on their case. Normally, the judge will develop the case, which means the judge will ask both parties questions. First, the landlord talks, and after the landlord is finished, then the judge will give the tenant a chance to talk and ask questions. The tenant can present defenses, ask the landlord questions, or present their case. In Texas, if a landlord has said that the tenant hasn't paid rent, the tenant should bring proof of rent payments. In Texas, it's almost never a defense to not pay rent because the landlord did not make repairs. Also, it's important to know that in Texas, there are no counterclaims in evictions. A tenant can only defend an eviction. A tenant cannot countersue in the eviction against the landlord. The judge will issue a verdict at the trial. That means that the judge will decide whether or not the tenant will be evicted at the trial. If an eviction is granted, the judge is also allowed to award any back rent that the tenant may owe to the landlord, and if there was an attorney, can award attorney's fees as well. Both sides are allowed to be represented by an attorney, but an attorney is not required by either side. That said, we strongly recommend that if you're facing an eviction, you do seek legal assistance. After the trial, either side has up to 5 days to appeal. This is a very strict deadline. If the 5th day falls on a Saturday, Sunday, or a legal holiday, then the 5th day counts as the next business day. If you cannot afford to pay the appeal bond, then a person may appeal an eviction by filing something called a statement of inability to afford payment of court cost or an appeal bond that has to be on file with the court within 5 days of when the judge makes the decision. If it's not done, then on the 6th day, if the judge has granted the eviction, the landlord is allowed to request something called a writ of possession. That means that the landlord can ask to have the tenant removed from the property and their belongings as well by the constable. The landlord cannot request that if an appeal is filed. If a tenant files an appeal, and if the issue was non-payment of rent, then the tenant is required to make a full rent payment into the court registry within 5 days of filing the appeal, such as the statement of inability to afford payment of court costs or an appeal bond. Those forms are available at the courthouse. If the appeal is filed and the rent is paid into the registry, the tenant can stay in possession of the rental premises while the case goes on appeal. All evictions that were heard in JP court, when they're appealed, go to county court at law. When the case is on appeal at county court at law, it's a de novo trial, which means it's a brand new trial. The judge there doesn't want to hear what happened in the JP court. It's a brand new trial, as if there had been no trial in JP court. And again, it's the same process, except that instead of being served, you'll be sent a letter from the court letting you know when and where the trial will be. And at the trial, both sides are allowed to put on their case, which means give testimony and present evidence. The landlord will go first and the tenant can go second. If the eviction is granted, there are 10 days to appeal. After the 10th day, the landlord is allowed to request a writ of possession if the landlord has won. From that point forward, it goes to something called the appellate level, and then you're looking for error at the trial court. It's not a new trial to appeal from county court at law. It's a review of the trial that was held at county court at law. If you've gotten a notice to vacate or you've been served with an eviction, we strongly urge you to seek legal assistance. There are many legal aid organizations across Texas. I work for Houston Volunteer Lawyers. Our phone number is 713-228-0735, or you can apply for assistance online at www.makejusticehappen.org. I hope that this has been helpful, and I hope that you don't need our help, but if you do, I hope you reach out. Thank you, and have a good day.